Welcome back to Face Off. Claire and I are discussing jury selection with our guest Karen McArthur, a criminal defense lawyer, and Doug Hunt, a former Crown Counsel. Doug, in the pre-interview we did with you, you said that in most cases the best jury would be just the first 12 people that came in off the street, but that's not how the system works now. I mean, defense lawyers and Crown Counsels are allowed to reject jurors, and it seems to me there's some kind of bizarre way they do that. Could you talk about that a bit?
Sure.
Do you think that they shouldn't be allowed that at all?
Well, it may be an exaggeration to say the best jury is the first 12, but in principle, you're looking for people who are coming off the street. They're not trained in this. They're going to give it their honest best effort to listen to the evidence and return a verdict based on what they hear and apply the law as they're told. Now, there's a system in place that allows the lawyers for the Crown, for the defense, to challenge certain jurors and for various reasons ask that they be excused and not sit on the panel. For the most part, it is a combination of intuition and the processing of a relatively small amount of information about the individual, plus looking them in the eye before you make
Karen,
that
you have
decision.
a problem with that?
No, that has never worked very well for me.
What do you want?
Well,
Very well for a lot of years.
Doug is referring to peremptory challenges, and I mean, it varies how many peremptory challenges you get, depending on the seriousness of the case.
That's challenge without cause.
Right,
Is that...
challenge without cause. And what's basically happening there is either the Crown or the defense is excusing jurors based on, as Doug says, whether or not they're able to look the defendant in the eye from the defense perspective, and also on prejudices and assumptions that we have about how a particular person, based on the way they look, might think.
What do you want to do that you can't do now?
Well, I would like to, in cases, be able to ask questions about people's opinions about drugs, about members of certain communities.
Why?
To weed out people with established biases and prejudices so that people can get a fair trial. So that I was referring before to clients wanting to believe, the people that are on trial wanting to believe that their lives are in good hands. They want to look up at that jury and see that they are, in fact, being judged by a jury of their peers. I represent a great deal of black defendants, and even in metropolitan Toronto, where we have a very cosmopolitan city, very few black jurors make their way to sitting in the jury box.
So what about that? What about racial bias? I mean...
Well, racial bias, there are other features of society today that raise questions as to whether or not somebody could be impartial. The courts have acknowledged recently, certainly here in Ontario and in Metro Toronto specifically, that racial bias is one of those features of society today that raises realistic potential that it could affect the impartiality of a juror. There are other features that people would point to.
What about otherwise? Like, I'll give you an example right now. There's a lot of people who don't like feminism, who think that the reports of violence against women are grossly exaggerated and all kinds of men are falsely accused. There's what I would consider a bias. Shouldn't you be able to check for that?
You should be able to check for it, and in the case of racial bias, there's a body of evidence, social science evidence, that suggests it exists. If somebody can point to a body of social science evidence that shows that these other features also are present, then that's the case that you make to the judge to allow you to ask questions. But it's not at the time of the selection that you gather that evidence. That has to be there in advance. Otherwise, what we do is we bring in citizens who are going to try to do the job. We throw them open to a whole series of questions, 239 of them, 94. In the Simpson case.
And not only that, but in the Simpsons case, well, in other trials, as I understand, in the U.S., they actually have private investigators who then check up on the jurors after that.
Well, I was just going to ask Karen about that. Like, jurors can lie, or potential jurors.
Sure, but if jurors are getting up there and lying about whether or not they're prejudiced or biased, why would we have any faith in the jury system itself? Because they take an oath to...
Well, I seem to have more faith in the jury system than you do. You want to grill them.
So you have faith in just throwing up the
Let me just pick up on Judy's example that she gave about this feminist stuff. Basically is political views. You want to screen people out for their political views?
Well, you want to screen
and you want to assume, do you really assume that because somebody has a different political view than you do or Judy does, that they can't judge a case based on the facts? I think that's an insult to most people.
I mean, if the jurors are getting up there, the prospective jurors, and they're asked this question, for example, could you decide this case fairly, and notwithstanding that the defendant is a black Jamaican immigrant, and they say no, my defendant doesn't want that person sitting on the jury.
There's a misperception
here,
question. Isn't there? Bias doesn't mean that somebody is impartial when it comes to judging someone else on the facts. We all have biases.
Right.
Yes. The question is, can you in the rarefied environment of a trial process, set that aside and still judge the case on its merits?
And Claire, those are the questions that we're able to ask.
But we assume judges can.
We don't just go in there.
You don't ask judges questions, and they have biases.
Certainly, if information comes to your attention that the judge is biased against you, you can always bring a reasonable apprehension of bias.
Here's some of the questions they asked the Simpson jurors, okay? When is violence an appropriate response to domestic trouble? Are you divorced, and if so, did you initiate the divorce? I mean, how does that indicate bias?
Well, those questions are much more free-ranging than the questions that Doug is speaking of and the questions that I'm familiar with using in screening out prospective jurors. In our cases, we're able to say, would you be able to decide this case fairly and based solely on the evidence, notwithstanding X or notwithstanding Y, notwithstanding that this case involves guns, or it involves drugs, or it involves bikers, or a black Jamaican?
So why was it?
Well, we've got to take another short break, but we're coming back. Judy and I will return with our guests, Karen McArthur and Doug Hunt, in 1 minute.